Dr. Siddharth Das is an alumni from this institution, passed out in 1993, as I am given to understand. Professor Dr. CB, I think some of the participants they are not muting. Some of the participants they are not muting and unnecessarily disturbing the proceedings. Am I audible to the participants?
Yes, sir.
Yes,
Yeah.
sir.
I have to request to the participant to mute their audio. Otherwise, it is unnecessarily creating disturbance. Professor Dr. CB Jani, our fellow colleague, esteemed participants, I welcome you all. As I understand that a lot of faculties they have joined from outside the state. I welcome Dr. Bastia from AIMS, Rishikesh, and many more. In fact, I am not able to recollect and recapitulate. Now, this pre-platinum Jubilee CME was conceptualized only with an objective of reuniting many of the SCBNs that we have not able to reunite with them. This became a digital platform on which we can always interact so that they can have a nostalgic memory of their own alma mater. For those who have joined today, this is my ritual all the time, that SCB has already stepped into the 77th year, but we are observing the Platinum Jubilee because of the COVID pandemic, which made the havoc for the last 1.5 years. This time we made it a point that we will definitely observe it. Let COVID be there, but we'll observe it. How long we can wait? It is already 77th year. So we have made up our mind, if physical, so far so good. It may be hybrid, and if Corona is not favorable, then we'll make it purely digital also, but we are going to hold it on 26th, 27th, and 28th of November. Now, this pre-platinum Jubilee CME is the first component of our celebration, which will be completed on 31st of August. All 37 departments, they have participated. Now we have already crossed the 2/3 mark. Only 1/3 is left. 1/3 departments are left. The best part is that each department has done wonderful, marvelous work through this presentation. Each department have projected their departmental activity through this CME platform. The speakers have been outstanding from all the departments. Yesterday, it was the Department of ENT. And what we saw, both the alumni, Dr. Mahanti and Dr. Deepak Naik, they were presenting wonderful work up there. Their own original work they were presenting. Possibly if we did not have a CME like this, we would have missed it for the rest of the life. So I'm sure every day we are knowing a lot of new things on that particular field, and it is enriching one and all. Now, this is the first page which is going to be over on 31st August. We are plunging into the second page on 13th of September. That is the 75 for 75, which is exactly 75 days before our main function. Now on 13th, we are having a function to kickstart the celebration. Now, till 31st August, it is an academic jubilation, academic celebration, academic extravaganza. But from 13th of September, it is going to be a combination, a conglomeration of the past, present, and future with an entertainment program. Every department has already made their program, what they are going to project on their given day. All the stakeholders who are connected with SCB, they will be participating on these 75 days as the day assigned to them. I welcome you to that function as well. If you cannot come physically, we are having everything live streamed through the YouTube, and we'll provide the link. Each department head is requested that they should give the link to all the speakers. and all the participants, they have joined in our academic extravaganza, extra bonanza, whatever you mention it. Now, when we come to the final function on 26, 27, and 28, that is again, we are not sure in which form we are going to conduct it, but definitely it will also be live streamed, and we welcome you all to participate and enjoy the whole program. We have crafted a beautiful program that is full of people who have done some original work, and they are the who's who of the country and from outside the country. We'll definitely send you the program, so please join. Yesterday, it was very heartening that our Honorable Health Minister came in and he addressed all of you and has encouraged to do our best so that we upkeep the image of SCB. And definitely SCB in the path of progress, we are going to have a transformation, and we are going to have become one of the largest world-class health facility by 2024. With these few words, I again extend a warm welcome to all of you. Please be part of our jubilation. We will definitely remain connected, and do give us your contribution in the development of the SCB Medical College, Cuttack. With these few words, I hand over to our Vice Principal and Professor and HOD of FMT, Professor Geeta Sahu, to conduct the proceedings. Thank you.
Thank you, sir. Respected Dean and Principal, Professor Datiswar Hota, sir, our guest speakers, Professor Siddhi Jani, sir, and Dr. Siddharth Das, and alumnus of SCB, all esteemed faculties present today of SCB, as well as all FMT faculties of other institutions from all over India, and all the residents present with us today. A very good evening. To begin with, I would say what is not documented is not done in medical practice litigations. Extending the risk management dimension, failure to document relevant data is itself considered a significant breach of and deviation from the standard of care. The patient's record provides the only enduring version of the care as it evolves over time, and a reference work of value in emergency care, research, and quality assurance. While writing the record, the clinician should keep in mind the possible reader audiences for the record, because this will help achieve sufficient clarity, avoid cryptic communication styles, and achieve the goals of the record in both patient care and liability prevention. Like many other people-based professions, communication skills are essential for medical practice also. It is a backbone over which lot of areas of patient care rests, such as first contact patient interview, sometimes counseling of the patients, explaining them the treatment, and explaining the risks, etc. Even counseling is required for in cases of bereavement or mishap. Sometimes we have to detail about information before taking an informed consent, and lot more other areas of patient care. The person giving consent must share an understanding with the doctor of how the normative boundaries between them will be redrawn. This mutual understanding is achieved through successful communication between them. So having said that, our topic today, documentation and communication in medical practice, is well justified to be discussed in this August gathering. Now I would introduce our first speaker, Dr. Siddharth Das. He is currently additional professor and head of the Department of Forensic Medicine and Toxicology, JIPMER, Puducherry. He is an SCBN of 1993 batch. Dr. Das has 34 research publications in different international and national journals of repute, of which 19 are in PubMed Index journals. He is an editorial board, reviewer board member of various journals like Forensic Medicine Anatomy Research, International Journal of Forensic Medicine and Toxicological Sciences, Indian Journal of Forensic and Community Medicine, Journal of Indian Academy of Forensic Medicine, PLOS 1 journals, etc. He has been an expert speaker. He has given 15 oral presentations in different scientific conferences and meetings, and 3 presentations as invited guest lectures. He is a member of different associations. He is a committee member for Institute Sexual Offense Related Cases and Cadaveric Organ Transplantation Team. He continues to be the committee of experts for CBCID cases, for giving expert opinion or second opinion in alleged medical negligence cases, custodial death cases. He is external expert in the subject of forensic medicine for Apex Trauma Center of SGPGIMS Lucknow. He is holding the post of Joint Secretary, South Zone of Indian Academy of Forensic Medicine, which is the oldest and most respected national body of forensic medicine experts of India. So Dr. Das, I will invite him to start his presentation on importance of documentation in medical practice. Dr. Das, please.
Thank you, madam, for all those kind words. Before I start today's presentation, I would like to express my heartfelt gratitude to Principal Sir and HOD Madam for giving me this opportunity to represent the department on this prestigious occasion of this Platinum Jubilee celebration of SCV Medical College. Now, the topic for today, as you can see, is prevention of litigation in medical practice, importance of documentation. These are the overview of my presentation. First, what is documentation, the different types of documents, the general principles of documentation, the purpose of documentation, what will be the retention period of different documents, a little bit of legal insight, and a few case discussions that I have got at my disposal. So starting off the thing, now what is documentation? Now we are not going into the exact definitions or the classical definition of documentation. This is what has been taken from the usual meaning of documentation. If we are allowed to say that, it is means any communicable material that is used to describe, explain, or instruct. That is any communicable materials, any matter that in our context we would like to say that any matter that the doctor he wants to communicate with the patient. Now, it can be in the form of description, it can be in the form of explanation, or it can be in the form of instructions. Now, very often in medical practice, most of you are into medical practice, so you very well understand when you have to describe the things, okay, and when an explanation has to be given to the patient, and what are the different types of instructions. We are not going to details of all those things. Now the next thing is this documentation. The documentation can be mainly the usual practice is that it is in the form of papers or what we call as a hard copy. And nowadays, with the onset of this online things, we have these documentations can be in the soft form also. The different things like you have the email and the various social media like WhatsApp. It can be SMS messages also. Now, apart from this, it can also be in the form of some audio messages or the video messages. For example, whatever suppose we are having some online consultation. It is through some phone. Now, when it comes to the loss is that whatever the consultation is given, it should be documented and it should be traceable. And second thing, law has to see that the author of that consultation, be it your paper form, be it your online form or audio form or CD form, all these things should be traceable. That means the person who has done this consultation, he should be traceable, and whatever the consultation had been done, it should be in the form of documents so that it becomes easy for the law to understand in case of any litigations that what exactly transpired, what exactly happened in the given circumstance. So that is briefly about what is documentation, and it can be in which forms. Now, different types of documents. I've just jotted down different few things. Now, this is not an exclusively, some of can be missing. For example, to start off, we have the patient registration form. On a patient registration form also, people at times they become a bit lax while filling it up, because, and especially when it comes to this insurance claims, one has to be very careful. So exact information, whatever is there regarding the name, age, sex, race, in fact, including the TA also. This address also has to be correct. Next is the case sheet. Now, when you're talking about the case sheet, this is a this basically contains everything about the patient, starting from the this complaints to history of the case, whatever consultations had got in, any referral, what are the different investigations that the patient would have been told, what is the treatment and everything. And inside the case sheet, at times you can have the consent form. Especially this is, as all of you understand, this is required in cases of operative procedures, the consent form. And not only the operative procedures, for any examination any examination one starts one wants to have, the basic thing is that the consent form has to be filled up. Now, gone are those days when consent was implied. Nowadays the law is very particular, law is very clear. Whenever it is talking about consent, it is means an informed consent. Okay, so apart from the informed consent, all of you are also aware of a term which is called as an informed refusal. That is, the person is not interested for that particular procedure. He has got all the autonomy, he has got all the authority to go in for informed refusal. So documentation of informed refusal is as much important as documentation of the informed consent. Different type of charts are also there. These charts, usually the temperature charts or this input output charts, these are the words which are maintained by the nurses, but of course the nurses in this case, they're part of the team, so the doctors cannot say that the charts that is maintained by the nurses were not done properly, because they have to work as a team. Medication records are there. You have these prescription slips, then referral slips, investigation slips, and the investigation reports, and the discharge summary. All these things are different types of documents. I hope I have covered everything. Some of the, as I told, it may not be the exact inclusive list. Okay. Now the next thing is about what are the general principles of documentation. Documentation, whatever it is being done, it should be complete and legible. By complete, as I told you, whatever the information is being put there, it should be a complete information, and it should be properly legible. Means the person, suppose the matter has gone for any litigation, the person who is going through the documents, the experts, they should be able to understand what exactly transferred, and for that it has to be legible. Next thing, the date, time, and proper identity of the observer or the healthcare worker. That means the person who has observed those findings. Very often it is noted that the people, the healthcare workers, be it the doctors or the other category of healthcare workers, when it comes to maintaining writing the date and the time, they are, and especially the time, it has been noted that they're not so particular about writing the time. All of you understand the importance of that, especially suppose if you're going for some, when you're maintaining the progress report, progression chart, and this suppose that EA part, the operative part, and something happens, unfortunately some untoward incident happens. In that case, if the documents are seized by the court, if the court wants to go through the document, then they have to see what the exact sequence of events, and for that they have to see the time of the events, what exactly happened, where the matter went wrong. So noting the time is also equally important, and proper identity of the observer. Very often it is seen that they will just scribble something, they'll be scribbling their initials, and that is not. It should be signed in such a manner that the author or the person who has observed that, he should be identifiable if the situation so arises. Certain thing about the ethics in documentation, that is also required for, especially with cases like, for example, HIV cases. So what earlier used to be the practice is that, over the case sheet, it was boldly written in some red letters or some red ink, and it was a circle of that HIV positive. Now what happens is that as the society is still attached, there's still so much of stigma is attached with this case, there's a chance of that such patient may get ostracized, and the healthcare workers they will feel reluctant to come and give proper ear. So in those cases, ideally what is to be written is that they can mention something like PLHA. As all of you know, it stands for people living with HIV or AIDS. Or else they can mention something like RVI, like mentioning that this is a case of retroviral infection. So idea is that to give other healthcare workers who may have to deal with these patients who may not be aware that this is a case of HIV. They will be made aware, and at the same time, the rights of the patient is also maintained. This is one thing that one should be careful about: the correct the mistakes with sense and legality. They mean if it is a possibility is always there that while writing the the notes or the prescriptions or whatever, giving the investigations or anything, some inadvertent mistakes may creep up. So in that case, what is to be done is that the entire thing should not be scraped off. It should not be whitened off. Just one strike that should be there. So the idea is that one should be able to know, suppose anyone going through the note, they should be able to know that what exactly was written wrongly. And because the idea is that if a total is right, putting up, then the matter may go against the ear. They may think that something gross mistake was written there. So any corrections, it should be strike off with one line, and it should be readable. Ethics in referral consultation, all of you are aware of this. I'm not exactly going into this. Ethics in referral consultation means this basically deals with those referral cases. And since it is a teamwork, so one should be very careful to see to it that there is no wrong impressions or there's wrong things written in the wrong comments written about if some other person has by mistake written something wrongly, that should be maintained, because these are the things which give rise, these are the things which are the fodders for this the negligence cases. The patient will take a cue from there, and they will like to file a case of negligence. Last but not the least, these are the things one should be, since now it is the advent of this the online things, one should be very familiar with the online or the computer documentation. And apart from that, certain other things which are, though not so much in practice, but which have come up, the concept of the doctor writing pads, then the Google speech recorders. So those things, although they are meant to help the doctors in this, but one should have proper knowledge in handling that. And the main idea is that whatever they're telling or writing, in case of this doctor writing pads or Google speech recorder, it should be written properly so that it should be properly identifiable. Okay. So that is in brief about the general principles of documentation. Now the next slide is about the purposes of documentation. I will just go through it. The quality of the care. Now the thing is, the only thing that will speak for the quality of care or the the care that is taken by the doctors or the other healthcare workers is that the case sheet records. No one is going to see what you would have sent verbally, how much amount of sympathy or empathy you would have given to the patient. So the quality of care is only expressed, or the quality of care is only seen through the documents, if the documents have been maintained properly and correctly. And secondly, the coordination of the care is also necessary, because as I told you, since it is about different category of healthcare workers are involved, so the document has to be properly written so that the person who is seeing this, for example, the nurses or other junior staffs, they should be able to understand what exactly is written. Okay. So that is about the coordination of care. Execution of care, that is equally important. I mean, one thing is that the quality of care. Secondly is that the instructions that is given, the instructions have to be properly carried out. For this, the execution is also equally important. For example, if I'm allowed to say something, when I was doing my UG in the mid 90s in SCB, I remember one particular case had happened, which created a lot of human furor. So in that case, what has happened is that one particular patient, it was suspected to be a case of malaria or something like that. He had been given, whoever has prescribed it, he had written as quinine or something. It was not properly mentioned that in which route has to be given, with what it has to be given. Now, unfortunately, the student nurse, he saw it and he just gave it IV without giving it through the solutions. Okay, the IV drip. So the patient went into immediate cardiac arrest, and they're done. And later on, a lot of things had to be done. We don't have the time for all these things. So the reason why I told is that, just to tell is that if the instruction would have been given properly, if the person who is at the receiving end of the instruction, if he would have understood what exactly is being expected of him or her, then he could have executed the job properly, flawlessly. Now, the most important is the purpose of documentation is that we the doctors, the healthcare workers, we are under the legal obligation. Okay, no? The law demands that, whatever you're doing it has to be properly documented. That is, as I told you, I mean, whatever you're doing it can only be measured, it can be only understood, it can only be read through the documents or whatever it has been written, whatever is available in the written form. So that only the law will try to understand, law will assume, the law will draw its opinion that whether the proper care has been given or not, proper instructions have been given or not, whether the proper execution of instructions have been carried out or not. So I think, so with that, so there's a in brief about the purposes of documentation. Now the next slide is, it is talking about why is documentation legally important. Yeah, that is already, I think Geeta madam has said something to this effect during her introductory speech. Documentation is evidence. Okay, so if you have not documented, there is no evidence, it is understood that you have it has not been done. Okay, and that is the thing, as I told you. I mean, how is documentation usually legal? In the plaintiffs, all of you understand means the complainants. The complainants, they use it to prove that standard of care was breached. Now, all of us are aware of the fact that as per the Indian laws, and especially when it comes to cases of medical negligence, it is for the plaintiff or it is for the complainant. It is for the plaintiff or the complainant to prove that the doctor or the healthcare worker had been negligent in his conduct, had been negligent in his duty, not the other way around. But of course, there is a concept of this res ipsa loquitur, which means that the thing or the fact speaks for itself. In that case, the nature of the negligence done by the doctor is so evident to a common man is that in that case, the doctor has to prove that he was not negligent, he was innocent. Otherwise, for all other cases, it is for the plaintiff or it is for the complainant to prove that the doctor was negligent. And similarly, the defendant or the doctor, he has to prove that the standard of care was met. Now, when we are talking of the standard of care, law sees minimum things, that the minimum things that law sees is that there should be proper care, skill, and knowledge. Okay, whatever is expected of a doctor, given his specialty and his level of knowledge. So minimum thing that is required is the minimum amount or the required amount of care, skill, and knowledge. That is the minimum or the basic that is expected, which will help the which will help the doctors not land up in any sort of legal hassles. And for that, documentation is extremely important. So kindly remember, this is a thing. Court believes you document only. In court, if it is not documented, it was not done. Kindly remember this statement. In court, if it is not documented, it was not done. Okay. No matter what type or kind of document is used or kept, anyone reviewing it must be able to determine what transpired. Okay. So what exactly happened in that particular case, what exactly transpired, the court must be able to understand that. So the bottom line is that you must be able to determine what happened, to whom it happened, by whom it happened. Okay, who was the the person who was supposed to be negligent, when it happened. That is the thing. I mean, what is the sequence of events? Because many times what happens is that when you're getting the progress reports, because of shift duties or change of duties, many people may be entering their reports. So who is entering at what time? That has to be properly mentioned in the case sheets. Why it happened, of course, that has to be decided by the court, along with the experts. The result of what happened, what exactly happened. I mean, did he suffer from any simple injury, grievous injury, fatality, whatever? That is the thing. So these are the bottom line. Yeah, next is about the retention period of the medical records. Now, all of us need to understand that what should be the minimum period that the medical record should be maintained with the hospitals, so that in case of any eventualities, in case of any eventuality of the matter going to the court, and the court wants to get the documents, or the relatives want to get the documents, it can be procured to them. So this is about about 2014-15 one. I hope it is visible. If not visible, I'll just read it out. Here they have the government. This is by the Ministry of Health and Family Welfare, Government of India. So this came out in 2014-15. They have talked about two types of documents. One is a hard copy document and there is a soft copy documents. Now the hard copy document, what the guideline says is that the inpatient records and the outpatient records, they have to be maintained for a minimum period of 3 years. I repeat, inpatient records and outpatient records have to be maintained for a minimum period of 3 years, and medical legal reports for a minimum period of 10 years or till the case is open or till the case is not closed. That is for the hard copies. Now, as far as the soft copy is concerned, the concept of soft copy has come up. As you know, they're kept in, this in the form of CDs. They're kept in the form of external hard drives. They can also be kept in the system itself. So what the our yes as a guideline says, it should be minimum for the last 10 years. The document should be available in the digitized form for the last 10 years. And if it is more than that, that is well and good. But this is the minimum. And according to this, the different institutions, they can go ahead with their plan, but it should be minimum. For example, right now in our institution in JIPMER, what we are following is that every institution has got its medical records department. Okay. Now, our medical record department right now, what they're doing is that because of
sorry for the interruption, Dr. Siddharth.
Yeah.
Yeah. Can you be a little faster? Can you come to a conclusion, because time is also a factor?
Okay.
Please try to
yes.
complete.
Yes, sir. Yes, sir. I will just keep through few slides.
Yeah.
Now, documentation error and the law. I mean, in case of any, now this is what it can be go through the state medical council, civil or criminal courts, or the consumer courts. Now, there's a limitation period for the civil cases, that is 2 years. And when it comes to this, what should I say, the different IPCs, it can be usually the IPCs that are applied at 337, 338, and the 304A IPC. 337 IPC, it deals with the injury that is the hurt that is caused due to the rash and negligent act. 338 IPC, grievous hurt caused due to rash and negligent act, and 304 IPC, it is death caused due to rash and negligent act. The minimum time period is 2 years. Okay, but cases are there where it can be entertained depending on that particular case more than after 2 years also. Okay, so few case discussions. Sir, can I just take few more slides are there, sir? Can I just hurry through it? Sir, principal, sir? Okay, I'll just hurry through it. The one case, with the Canada case, we'll just see. In this case, the patient was prescribed gentamicin for the first time. And the patient came to the hospital. So as we all know, gentamicin has got its toxicity associated with it. The physician was sued for failure to warn regarding the risk and the presence of, he also failed to tell about the presence of other options, and he was sued for that. Now, the physician argued that I had discussed the case with that patient, whatever the, the risk that associated was never told to him, but unfortunately no documents was found to prove that case. Okay, so from here you can understand what is the importance of documentation. I'll give another example from, it was happened in this Meenakshi Mission Hospital in Tamil Nadu. This case dates back to 1995 when consumer protection just came up. The doctors, were put under the purview. A 13-year-old daughter of the complainant, he was admitted with for cleft lip operation. He was taken for surgery around 9:30 a.m. He declared dead at 10:30 a.m. So district forum, they heard the case and they found the hospital negligent and directed them to pay the required amount as compensation. The doctors, they found a revision petition was filed by the defendant stating that death resulted not because of their negligence, death resulted because of the inherent anesthetic complications associated with the case. And they also went to the National Consumer Redressal Forum. Now, here is the remarks of the bench from the National Consumer Disputes Redressal Forum with respect to this particular case. So in this case, if you read, it is they have clearly mentioned that although they have told that two anesthesists were present, but it is not very clear what those two anesthesists were doing. And secondly, nowhere in the the case sheet or the reports was it mentioned that the anesthesists have written there the findings, or they've given their preoperative checkup, whatever they're expected to do. So as a result of it, this case, so it didn't stand. The doctor along with the particular hospital, they had to pay the required amount of fine. The only reason being there no mention was nowhere in the whole progress record it is mentioned as to who administered this anesthesia. Okay, So the anesthesists, they failed to properly document their things. And okay, so this is the last case I would like to discuss. This case recently we discussed about a case of intrauterine death. The patient party, they tried to say it as a case of medical negligence. These are the timeline of events. 38 weeks pregnant female came with complaints to a particular hospital. He came with complaints of no abdominal pain for 1 hour on 13/4/2021. The case sheet records it was produced to us. So what was noticed that they had noticed cephalic placenta along with a fetal heart sound was present. That is what they had noticed. And he was told to go home. The next day morning, again the patient came with lower abdominal pain, and there was loss of also fetal movements in the night. In this particular, this morning, the fetal heart sound were noted to be absent, along with the tobacco-colored fluid discharge was present per vagina. Now, tobacco-colored fluid is seen in cases of intrauterine death. Now, the next day, the case was brought to us for autopsy. So this is what we found: a full-term baby, and on examination of opening reflecting the scalp, this is what we saw. As you can see, the skull bones, they are not maintaining the normal architecture. In fact, this is supposed to be the sagittal suture which has gone. So this basically what is reflecting is that a case of what we call as the overriding of skull. And before starting the autopsy, we had subjected the fetus to this X-ray examination, and from which, as the arrow points out, as you can see, there is a depression. That means this speaks about the overriding of the skull bones, which occurs in cases of intrauterine death. Radiologically, this is called as a Spalding sign, and for this, minimum period the patient is it takes around 4 to 7 days to develop. Now, why we are discussing this case is that then we told the police, the investigating officer, kindly peruse the hospital case sheet records. This is what we went through the hospital case sheet records. As you can see, there is a 13/4. They went for discussion, and in this case, they mentioned as fetal heart sound is present. And another thing noted was that whoever has done this, it is not very clear who is the person who has checked. And one thing very intriguing fact that came to the notice, right in the middle of the paper, it is written as PTO, and also we can see the change in the color. So we are not very. This is a Xerox copy we got. We are not very sure whether this is exactly the sequence of events or it is some sort of the manipulation would have gone into it. Okay. Now, kindly note on 13th, and this was on 13/4/2021. The documented time is 23:56. Okay, fetal heart sound is mentioned as positive. Now, the next day, if you see 11:20 a.m., the next day morning, fetal heart sound was noted to be absent, along with the tobacco-colored fluid was present. But from our autopsy findings, we clearly found the Spalding sign was there, and also the brain matter liquefied. So the time since death that we had given as a minimum, the fetus would have died 4 to 7 days. But unfortunately, in the previous slide that you saw, it was noted that fetal heart sound was present. That means something is pretty not normal there. Something would have happened. So we are not very clear. Now this matter will go to the experts. The experts will decide. Okay. So that is the thing. So with that way, so the take-home message is that good medical care generally means a good medical documentation, whereas an inadequate medical record generally reflects poor medical care. So one has to be very careful about proper documentation. So with that, I end my presentation. Thank you once again for a patient hearing. Thank you all.
Thank you. Thank you, Dr. Siddharth. Please connected till the end to take up the queries from our audience. Now, I would now introduce our next speaker, Professor Dr. C.B. Jani, sir. Professor C.B. Jani, sir, is a medical legal consultant. He is a MD Pathology, MD Forensic Medicine, DNB Forensic Medicine, LLB, PGCC Hospital Management. Now, his institutional contributions are Institutional Ethics Committee member, and he was a Death Review Committee member. Then he is the editor-in-chief of Journal of Indian Academy of Forensic Medicine, 2008 to 2009, General Secretary, Indian Academy of Forensic Medicine, 2013 to 2016. He is the treasurer presently, Indian Academy of Forensic Medicine, 2019 to 2022. His quasi-academic assignments: he is a member Board of Studies of Wildlife Forensics, Uttarakhand, expert member, Board of Studies in Pathology, Microbiology, Pharmacology, Forensic Medicine, and IHBT, the Maharaja Sayaji Rao University of Baroda. Selection committee member, he was in 2019 of Forensic Medicine at Gujarat Public Service Commission. And he has received the award, Excellence Award for Research Work, awarded by Gujarat University and BJ Medical College 2016. Now I invite Jani sir to speak on importance of communication and consent in medical practice. Jani sir, please.
Yeah. Good afternoon, respected Dean sir, Dr. Geeta madam, Dr. Siddharth Das, my previous speaker, and the participants, Dr. Amrinder Nayak and host people. It is my pleasure to be part of this academic fiesta hosted by SCB Medical College for the second time in the state this year. In 2021 January, first month only, it was my pleasure to be part of the 42nd annual national conference hosted there, and I was fortunate to be there physically. The topic assigned to me is the importance of communication and consent in medical practice. So, if we see this tower, it has got 4 pillars. Those are the foundation, you can say, and on that, the entire tower is also complex with so many angles interconnected. So what I understand that those 4 foundation pillars are the pillars of communication on which the entire consent or any other related issue that rests. Communication, we all are medical doctors. Presently, many of us are teaching also. We were students also. So communication in the classroom, what is reflectivity? We ask, keep on asking in between that, okay, could you get it? We ask one of the students to stand up and re-narrate the entire thing. So it is not unilateral. To make it more reflective teaching, it is interactive and it is dynamic. Now, so far as medical practice and communication is concerned with the patient or relative, contemplate and summarize the content in own mind. I'll just brief you one example. When I was an examiner at second MBBS examination, and I learned very beautiful thing from one of the candidate, a second year student. I asked her that what is most common poisoning in India? She told me air pollution. So I modified my question that what is most common fatal poisoning in India? Then she answered with a nice smile, sir, pesticide poisoning. So before starting the communication, we should contemplate that what exactly we are trying to convey, and we should be summarizing the contents in our own mind. Second thing, to whom you are communicating. As a medical doctor, whether you are communicating with patient or relative, those are diverse educational and social strata, nursing staff, subordinate, colleagues, superior, extramural individual, authorized official, media or press. So identify the person to whom you are communicating, the intellectual or educational level, whether like Geeta madam taking a UG class, the level will be different. If the same Geeta madam is taking a PG class or PG seminar, the level will be different. So this is the basic thing, that the communication, the first and foremost thing is, what is the audience or to whom you are communicating. The mental status, many a time in hospital, patient or relatives, they are in agony due to that ill health and consequences. So that also we should be very clear about. Language, vernacular, social etiquette, these also matters. Like right now we are having 550 medical colleges across the country. So far as the government medical colleges are concerned, 50% seats are all India quota, meaning thereby that a student from Gujarat may take a PG admission in Cuttack, or a student from Berhampur may take admission at Ahmedabad Medical College. Now, in both the scenario, it is very less likely that they are well versed with the local language in vernacular, right? I can quote you one example that a very senior patient attended by a resident doctor from South India, old days I am talking about. Now, in that particular community, it was a custom to address by respect. And instead of that, the resident was just in earlier stage of learning the Gujarati thing. He said that tu means by first name. So the patient didn't say anything, but patient relatives all of a sudden got angry that how you can behave with this senior person by one name. So that is about social etiquettes. So far as the private medical colleges are concerned, please note that those deemed university, those are also without state boundaries so far as the admission is concerned. And one resident doctor who has graduated from one state may be expected to go to some other state where the language, social etiquettes may vary. So the first and foremost thing, why I'm emphasizing on resident doctor, because those are in teaching institution, those are the physicians of the first contact that we all of us know. Feedback about communication. So if, like Madam has kept that after this 20 minutes presentation, there will be question answer session, right? So it is not unilateral. Till I finish, it will be unilateral. But the moment I finish, then it will be unilateral, bilateral, multilateral, whatever. So whatever you are communicating, just try to have a feedback, whether what they have understood. So that is the actual completion of the communication. You can conclude as anything which is not clear to you, either to the patient or person, that I have tried to explain and communicate all the possible things. Still, any question in your mind? So with that, you conclude your communication, and maximum contents are delivered on either side. I'll just brief you till this matter is pending before the district commission, and I am involved as a medical legal consultant in the case. Now I am just briefing. There are 7 rows since 2010 till 2017. A patient was exposed, or he consulted 7 different doctors or registered medical practitioners. I will not name any of them. He was diagnosed as having squamous cell carcinoma in the mandible, middle mandible, lower mandible. Excision that improved quality of life? No. The result, I am specifically giving you the outcome that no, it didn't improve the quality of life completely. Following radiotherapy and chemotherapy, there was a radiation therapy necrosis or fracture of mandible. Still, there was no litigation. In 2012, the steel plate mandibular reconstruction was thus that partially improved his quality of life. Still, there was no litigation. Again, 2014 dislodgement of that plate for the reconstruction. He suffered the difficulty in speech and jaw movement, and still there was no litigation. In 2015, following the same complaints, he went to another group of doctors where the vascular fibula flap reconstruction of mandible that was done. Jaw movement was corrected. Gastrectomy feeding tube has to be placed in the abdomen. So litigation was there. In 2016, there was a gastrogaffin's study of esophagus, and ballooning was the therapeutic modality for that, but there was no improvement. Still, the patient did not go for litigation against that doctor. Again, 2017, no improvement, and still there is no litigation. So you can see the table that out of 7 consultants, the patient has filed the suit against only 1 doctor. All 7 are different doctors. So outcome of each modality was different. The question is why a particular doctor is being sued, not because of the cost of therapy and all. Answer is nothing else but the communication. So that is the most important part. What was not communicated, what I understand from the medical dockets provided to me, that patient was or relative was not informed or communicated that the ordinary pursuit of deglutition will be corrected by this surgery or not. Patient was already having some dysphagia, symptoms early in the 2015. So he was under the impression that this surgery will cure his jaw movement and the dysphagia part as well. But unfortunately, the 2015, that dysphagia part was never communicated that he will be relieved from that or not relieved from that. And that was probably that is the cause of filing the litigation. I will not comment further on the role of doctors because matter is still pending in the consumer forum. Come to consent in general, we are all aware that the definition of consent in civil and criminal cases both are different. So far as civil cases are concerned, it is under Contract Act, and the most important part is the section 13 to 22 that says common mind ad idem. Common mind means two persons having same mind. So that is the requisite which cannot be accomplished without proper and complete categorical communication. In criminal cases, the definition is long. I'm not going to theoretical part. I will catch some aspects later on. Consent in medical practice, it should be free, right? There should not be any fear, force, pressure. It should be voluntary. It should be clear. Now, when we say clear, clear in what terms? It should be clearly communicated. It should be intelligent. Intelligent means not the person or patient's relative should be in a position to exercise his or her intelligence depending on her educational and social status. It should be informed. It should be direct. Now, this is a direct consent part is very important because many of the times what happens, either intern doctor or the first year junior resident, they take the consent. This is base scenario. Many of times it is the nursing staff who takes consent, right? Yeah. So I'm talking something beyond that, that a team of doctors is going to operate, and that person or the head of the team is never communicating with the patient. So that is indirect consent, and many a times this causes the problem. So it is neither direct nor personal. Full disclosure, therapeutic privilege, all these things part Siddharth sir has already discussed. The history taking, this is also very crucial thing. Retrieving, history taking is not taking, it is retrieving. Role of communication is very important, right? Stepwise, ODP, we have been taught that origin, duration, and progress, right? So how to communicate, how to retrieve the relevant history, that is very important. I will just quote one case by NCDRC where the deliberate concealment of the past history, that was the ground of defense by the doctor. In another case, the surgeon deficiency in service for consent obtained for surgery through term re-exploration. So even we are re-exploring, right? Then also the consent is equally important. And in here, the doctrine of voluntary non-fit for injury that is applicable in civil cases, not in criminal cases. Just a few excerpt original petition at NCDRC, very famous case, Saroz Chandok versus Sir Gangaram Hospital. So the comments, I will just brief you a few comments. Informed consent was obtained for total abdominal hysterectomy. There was no necessity of trying to operate via vaginal route. So what is the carry home message? That consent is modality specific. Sorry. It is modality specific. After taking consent, vaginal route cannot be adopted. Second part, no consent was obtained for removal of ovaries in advanced plant surgery. So removal of organ, right? Or the chances of removal organ, that is not conveyed. The third point, no doubt in emergency, there can be deviation in the mode of surgery, but not in plant surgery, where express consent for a particular mode is taken from a patient, particularly where there is no emergency. Now here, no deviation from the planned modality should be there, except emergency. And as the forensic people would agree to me that justifiable and excusable, both the things are different. So here you will have to justify. When you say you have to justify, prima facie you are not excused. When you are saying excusable, means prima facie you are excused. Justifiable means you will be charged. Once the charge is proved, then you will have to justify. So that is the prosecution part, getting charged, that all part is there. So even in case of emergency, the risk of consent violation or some breach in that is very dangerous. In one of the case, this risk communication at the pre-consultation counseling was not done. So any complication, right? There are many complications. We are the medical literature is flooded with complications for each procedure. So at least 10% or more chances of a particular complication to occur, that shall be documented. That is what I feel. Wonderful initiative taken by government of West Bengal in the era of COVID, that they have notified and formulated a uniform consent form for the rhino-orbital cerebral mucormycosis in the month of June and only. So this is a nice footstep to be followed. At institutional level, a committee may be formed to formulate department-wise consent form, keeping in mind the common clinical cases. Like AIMS New Delhi Ophthalmology Department, it has got, I think, 194 pages document exclusively for ophthalmology consent. Retina, this cryosurgery or macular surgery, whatever. For every in English and Hindi, that 194 page document is there. So at the institutional level or departmental level or association level, like OBGY people for normal, the common ones, the normal delivery for cesarean section, for hysterectomy, consent form for blood transfusion or other indoor admission, hospitalization, consent of restraint and ICU cases, those can be prepared at the institutional level or at the association level. So the exchange of views are in a better way. Recently, there is one news item, consent form for medical procedures, unfair trade practice. This is something new, no deficiency or in service, not medical negligence, but unfair trade practice. Now, if you see the news item printed in the paper, it is something beyond the letter and spirit of the judgment. The judgment says that it is pertinent to note that it is a pre-printed form, informed consent come undertaking, having blank space for limited selective handwritten entries for the signatures. The main body of the form is pre-printed. Such consent form fits into any procedure, any doctor, and any patient. Now, this is the ratio or the spirit of the verdict, but in media, it has been circulated in a different way. We respect media. There is no issue of disrespecting those reporters or the print media. But whenever this is also a sort of communication, or you can say communication gap. So, summarize, communication is a vaccine. In the era of COVID, I couldn't find a better example, and consent is a drug of choice. So far as the communication skills are concerned, now CME, NMC, they are formulating that personal attributes part. But Harsha Jani et al. In 2017, they undertook one study and published the article of 360-degree evaluation of resident doctors. She is professor of ophthalmology at Gujarat only, and fortunately happens to be my wife, so I know. So now in that 360-degree means what are the personal attributes of a resident doctor with the consultant, with the peer, with the nursing staff, with the relatives, with the undergraduate students. So those are much important part. You have to supervise our subordinates that how best they are communicating the things. Otherwise, acute problems arise. And again, I'm repeating why I'm emphasizing on resident doctors, because those are the physicians of first contact so far as teaching hospital is concerned. And with that, thanks, madam. Thanks, Dean sir. And the host, I think I have not overshooted and tried to conclude within my stipulated time limit. So now it is time for us to discuss various aspects if the moderator feels good. Once again, Geeta madam, thank you very much. Dr. Amarendra, Dr. Soumya Nayak, and Dean sir, thank you. I'm happy to be part of this pre-platinum celebration. Thank you.
Well presented and informed talk. So we have some questions in the chat box. I'll first ask them. One question about documentation is, I think Dr. Siddharth Das would take up this question. what are the modern electronic formats or systems by which the clinical documentation is made by medical practitioners? Are these electronic format documents admissible in the court of law? This is a question relating to documentation.
Unmute, sir.
Siddharth, please unmute. Yeah.
Oh, sorry. So my understanding would be is that okay, if I'm wrong, anyone can correct me. My understanding would be these are admissible in a court of law because the thing that one should be we should know that who is the author of these things. For example, if you're talking about email, if the email has been sent, then it is very well understood that who has sent the email. Okay, that is admissible in a court of law. WhatsApp message has been sent, that is also we can know who has sent it, that is also admissible in a court of law. That is my understanding. And not only that, at times nowadays, hello. Nowadays we are getting, I think there is some echo.
Yes.
Nowadays we are getting even this, what do you call, the summons are also we are getting through WhatsApp. So that is my understanding. If anyone has a better knowledge in this, can correct me if I'm wrong.
Well, I think adjunct to the question, nowadays with the COVID pandemic, lot of consultations are happening digitally. Lot of consultation. I think this is all the regulatory body has also allowed. How it is going to affect as regard this illegality is concerned. Because we don't have any documentation excepting having an interactions about the clinical aspect or history. We give a prescription. Now, suppose something goes wrong with the patient, what will be the legal stand there for the doctor? To both of you, Dr. Siddharth Das and Dr. Jani.
Can I? Yeah.
Yeah.
Yeah. Good afternoon, sir. So far as the evidence is concerned, my knowledge says that what is evidence? Evidence is any document which is considered by the court of law or not considered by court of law. Now, very first thing, it is up to the honorable court to consider or not. Not to consider, there must be strong reason for not to consider. Now, for consideration, IT Act 2005 clearly gives endorsement to the digitally generated records. Even digital signatures are also authentic. So far as the hard copy and the soft copy is concerned, I can draw your attention to certain, I will not name the company, that is the mobile phone, maximum mobile phone sold in the world. That company has a personal computer and attached to that a digital pen, that with digital pen you can write on the prescription pad, and at the same time the same your handwriting or image will be reflected on your screen, and you can digitally save that. You can just give that piece of paper to the patient. You need not go for scanning and all. So court also is very lenient in understanding the situation, as sir rightly said, that in the era of COVID or where the workload is heavy, right? The preserving of hard copy all the time, that may not be specifically for the outdoor cases. So I completely agree that digitally generated records, to be precise, the medical records are good proposition for being accepted by the court of law, unless and until there is some doubt or suspicion that there has been some tampering or something. I just brief you, sir, one thing. Delhi High Court in age estimation cases, they said that digital X-ray cannot be accepted because there are chances of tampering. Now, the counterpart should have explained that, sir, we are ready to be cross-examined, and our this material can be sent to scrutiny whether there is some digital tampering or not. So we cannot go away with technology. The technology advancement is for human well-being. We are also human. We are serving the humanities. Right?
I will add to that. In fact, in the present context of the CPA, Consumer Protection Act.
Yes, sir.
Well, whenever there is an online consultation,
Yes, sir.
The physician gets the consultation fees first after it
Yes,
is
sir.
transferred. So there is
Yes,
a
sir.
clear-cut transaction of money.
Yes,
So
sir.
he is being paid for his consultation. Now on an online consultation, the examination part is out.
Yes, sir.
Only history and little bit of interrogation.
Yes,
Then
sir.
we give a digital prescription.
Yes, sir.
So there where the problem starts. This
Yes,
is
sir.
just I wanted to bring to the notice of everybody.
Yeah.
But any other question, Prasagita?
Sir, yes, sir. Another question is again regarding this documentation. I think Dr. Siddharth will take up regarding retention of hard copy of ML reports. How can hospital know that the concerned case is open in court of law? Like you told,
Okay.
pending case is there, then more than 10 years until it is done. You have to preserve it.
Okay, that's a very intelligent question, I would say. So no, that is the thing. So law, the guideline that is given by the Ministry of Health and Family Welfare, that is a minimum period of 10 years. Now, it is up to the hospital. It can go for more. Also, in some cases, it is also written. It is also noted that they can keep it for 25 years. That is the thing. Now, if my understanding would be, if the hospital wants to go in for extra year, then whichever the what should I say, the matter can be discussed with the respective police station or whatever, and they can always ask for whether the case is still open or whether the case is sub judice or the case has been closed. As simple as that.
Yeah, that I agree with Dr. Siddharth. Before going for construction, I think we should write to the district court or can be. Yes, sir. Jani sir.
May I intervene here, Dr. Sahu?
Others, sir. Namaste, sir.
Yes, please, because the area is of
Yes.
very much concern to me, and we have discussed this issue of retention of records at many forums.
Sir.
So I will just like to share my experience of working at AIMS.
Can you please,
to overcome.
Dr. Saab, can you please unmute your video also?
Oh, sorry.
Others, sir.
Okay.
Please unmute.
Yeah.
Please.
Sorry.
Yes.
Yeah. So what we have done at AIMS, of course, the guidelines are there for 10 years, and we know the practical difficulty that cases goes on for 25, 30, 40 years or so. Even I got a request from the police to provide the record of the Delhi Sikh riots of 1984. So what we have done, before 10 years, what we are gradually doing, that all the postmortem reports and medical legal reports, we are just scanning them and keeping it for the permanent records. And before 25 years, say right now it is 2021. So till 2000 record we have destroyed. We have made a committee, and all the records we have already digitalized and stored, so that if by any chance, if the court asks for the record, I can provide under the section 65 IT Act, as my dear friend Professor Jani has already pointed out, that we have to certify that machine worked fine and all those things. And the court happily accepts that. So that way we can overcome the problem of long-term storage as well, because we can digitally store all the records before 25 years or at least before 10 years, depends upon the institution's policy. So that the experience what I wanted to share, that to overcome this problem of long-term storage, the space constraints and the wear and tear of the papers and all those. So we can digitally store them, and we can happily make a record with intimation to the concerned police stations that we are going to destroy all the records before 10 years on this particular date, by forming a hospital committee, internal committee, and certifying it. So that way that problem can be sorted out to a great extent.
Thank you, sir.
Thank you, sir. Can I just add on to it? Madam?
Yes.
Madam, can I just add on to it? Yeah. Adding on to whatever other sir has told. Now, that is the advantage of digitizing the records. Okay, you can keep it, though the guidelines, the ministry guidelines says that for 10 years, you can keep it for 20, 30 years. So in our institution, where from 2002 onwards, we have it. And another guideline I think came up in 2018. They have called a digitized form can be kept for as long a period, and different softwares are also available. So you can not only keep it in as an external hard disk, it can also be kept as some form of software. The only thing is that there should not be any unauthorized entry by Otherwise, the people should not gain access to it. That is the thing. So that is the advantage of digitized form. Any number of
Thank you,
years.
Professor Geeta. I think I'll have to go. There is another meeting. Let me conclude from my side.
Yes, sir.
Well, I hope Dr. Bhanu Dubey would have been here also. Dr. Bhanu Shankar Dubey, I think all of you know your FMT colleague
Yeah, yes,
from
sir. Yes.
Bhopal. He was my MCA colleague. I should have informed him. It was a default from my side. You know, I defaulted. But all said and done, really, you know, I feel very privileged and honored all the time because the CME has really got us an opportunity to be linked to so many luminaries. I really feel privileged and very honored. I again, before I leave, because I have got a meeting going on the other side, I really thank on behalf of the institution, at the head of the institution, and kindly continue your deliberation. Third time, I think we are interacting. FMD department is a very busy department as regard academic is concerned, and they do not spare me any event. No event I am spared with. No, I think my friend Dr. Silvano has already surfaced. Dr. Silvano Sapeco. So from Goa. So we are very small, well-knitted family. And last time also he was there. I believe that the academic continues. I wish that all of you please join. We'll provide you the link and be part of the jubilation along with us. Thank you and looking forward for such occasions in future. Thank you.
Thank you, sir. I think I'll take up some more questions which are in the chat box. One question is there. I'll read out the question. Situations where consent is required, who gives it for homeless children or younger people less than 18 years? That is a question I think Jani sir would take up.
Yeah.
Yes, sir.
So far as under 18 patient is concerned, in whose custody the patient was there, whether in juvenile home or whatever home or rehabilitation center, number one, that person is authorized to give the consent for the procedures. The definition or doctrine of loco parentis, that who is the local parent. Local means not area wise or in a given situation. Number two, many a times we face situation where even the person is not in custody of any such authority, but brought by police for treatment. So in that situation, it is clear that the residential medical officer or the medical superintendent as a head of institution, after going through the documents and all these things, has been authorized to give consent in the interest of the patient.
Thank you, sir. Another question was there in the chat box. What are the ethics for referral or consultation? That was a question. I think
Myself and Siddhar, we are thinking that to whom it is addressed.
Dr. Siddharth Das can.
Yeah. The ethics for consult, these are very basic things that we know of. Ethics for consultation is that what I meant in this particular case is that since it's a referral case, one has to be, since the topic is about documentation, don't write anything. Suppose if there is a difference of opinion between the treating doctors, anything, don't write anything which puts the other person in a very bad way, and it tells that he has done something wrong. So that these are the things which may be taken up. Suppose the matter goes to the court, these are the things which may be taken up by the legal people. They will tell the see, there is difference of opinion. You people, he is not right. That person is not right, and that may be considered as a loophole, documentary loophole, which can be utilized by the this plaintiff and the complaint party. That is what was meant.
Thank you.
And if you talk about ethics in referral, it's a big thing.
Yeah.
So I restricted myself to documentation part only.
Okay.
Yeah, Jani sir can add
I-
on if he wants.
Yeah,
Jani sir.
Madam, can I?
Sir, please.
Yeah. The criteria for reference. Number one, either that a registered medical practitioner thinks that he is not competent enough to handle the situation. Number one. Number two, he may be competent, but the place where he is working, that is not well equipped to handle that situation or the possible complications of handling that situation. These are the two criteria for reference, which the ethics says, or even which has been endorsed by various consumer court judgments as well, that in absence of this, there is no need of reference.
Thank you, sir. I don't find any more questions in the chat box. If I think Professor Chandana sir is also logged in. If you would like to say something, Chandana sir is there. Or anyone has any comments or has any say?
The last thing, madam, as others have said,
Yes.
for preservation of records. Now, in Gujarat, at least in few centers, in Maharashtra, few centers, and in Assam, few centers, they have started the computer-generated PM reports, which is signed by the person who has conducted the autopsy. So now it is reverse what other sir is telling. From the hard copy, we are converting into digital format. Now, these are the situation where the digital format is getting the shape of the hard copy. So over a period of time, with widening of the applications of IT, these things will be more prevalent, and the question of preserving the hard copy of medical record, that will start get diminishing. I think Professor Adar sir, you would agree to me? Please unmute yourself and
Yes, definitely. We have made this computerized reports from 2013 onwards. I was talking about the previous reports. The reports
you're
which
right,
were
sir.
issued hard copy before 2000 or 1960s, 70s, 80s. So that problem was there. Now, of course, I think so many places we are issuing the computerized reports. So in due course of time, that question will not arise after say 10, 15 years. I fully agree with you.
Thank you, sir. Thank you.
So thank you, Adar sir, Jani sir, and Siddharth, and all. I'll now request
Dr. Jani, may I add
sir.
something to this?
Yes,
Because
sir.
all
Moderator is Gita, madam. Moderator is Gita, madam. I am just speaker.
Yes, sir, please. Bhatkur sir, please come in.
Yes.
Yes,
I
sir.
want to add few words to what Dr. Adarsh and Jani said, right? Because these modern computerized reports are prepared on a particular software, and in which once the entries are made and logged by a particular person for which he is authorized, then they cannot be modified, right? So they are admissible as it is.
Yes. Yes, sir.
Right, because they cannot be modified by the intermediate person, because it has got a locking system at various stages.
Yes, sir. That is true.
So that
Online
software
yes, sir.
has to be used.
With online reporting system, it is the
Yes.
inbuilt software. Yes, sir. Thank you so much.
Even all communication and government work is being done by this way only. So that a letter is sent by one person who is initiating, then other is approval, second is sanctioning. So once it passes through all these peoples or the officers, then it cannot be modified.
Sir, very true, sir. Even in Odisha, they have started the online medical legal reporting system.
Yeah.
It's not yet full-fledgedly, but they are just trying from the police level initiation of the case itself. They will register, and accordingly, the person who is doing that only, it will go to him, and he will fill it up and all. Thank you. So, Jani sir, you wanted to say something?
Yeah, madam, actually, Hota sir left for his commitment. He had one issue of this telemedicine. I'll just draw the attention to the all eminent persons and participants that an application like Practo, right? A patient or patient relatives can contact a particular doctor by that application, by paying fees that goes to wallet or UPI or wherever the doctor has given. Now, while opting that only, the patient or relatives, they are undertaking that this is history based only, and the physical examination is not included in that. So since I think in metro cities like Delhi, Mumbai, this Practo application is very popular, where not the COVID or contagiousness, the distance is a major concern. So specifically for follow-up and the first consultation also, like this app is very popular, and some other apps also are there in market. And to my best of belief and knowledge, there are no issues of litigation reported so far of this nature.
Sir, thank
you, madam.
Ilyas sir, namaste sir. Please
Namaste, yes, madam.
come in. Ilyas,
My concern is about the electronic documentation, madam.
sir, please.
If after 10 years, if the professor is retired, the password with the professor only, the remaining the documents is go where? If the court comes after 10 years, 12 years, the document is required in the court of law. How you can carry this document to the court? Because if the person is not available, passport is with him. The person he has performed the medical legal work is in the custody of this password.
Sir, actually, I like to add here
Yes.
what they were planning here as online medical legal reporting system.
Yes.
There will be an admin. Admin who will give it to the doctor. So the admin can also provide the report wherever it is required. And also the IO, he will also be a part of that. That those particular people concerned. Only that is the chain, which is which can get the report and they can provide.
Who will be admin in that particular situation?
Suppose I will say for our college, they were doing admin, one admin in administrative officer, he was to be the admin. Then they told FMT department is mostly dealing, so FMT HOD will admin. Then I told in the meeting that no, because injury reports are being given from hospital side, there should be the administrative officer who will deal with the hospital side, and since directly we get requisitions, the HOD FMT, so another admin should be HOD FMT. Like that we had planned, and though it has not finalized, but it has been started here. So then the process.
No, recently is not problem. Like whenever after 5 years, 10 years, if you want, a person is retired, then it's
Sir,
problem.
can I just come in, sir?
Yes, yes.
I agree to what Ilyas sir. Good evening.
Yes, sir.
Yeah.
Good evening.
Can I just come in? I agree to what Geeta madam has said. It is just like passing on the HODC, where you have the rotator. It is just the things are passed on from one person to another person. Similarly, a person who is if he is made the admin, okay, he, apart from the fact that, for example, he said we are also dilly-dallying with this idea a few years back, but somehow it didn't materialize for whatever the reasons. Now the thing is, the people who are mainly, as madam correctly pointed out, forensic medicine people will be dealing with this kind of documents, the medical legal reports, and especially if I'm allowed to say this, okay, medical legal reports. Another thing is, whoever the are writing those reports, they will have their individual login facility. Apart from that, another person will be there who will be the admin. Suppose in case of the person is being transferred from one place to another place, so obviously you won't be having that login facility. So in that case, another person who is made the admin, most likely someone from the administration side, medical record departments, or anyone from the FMT department, the HOD maybe, he will take care of the things. So I agree with what Geeta madam has said.
Definitely, though it should be on paper, sir.
On paper means?
This administration work, it should be on paper. If in absence of this, and in absence of this. We'll work
yes. That is that is understood.
Done by the post, so
Yes.
that the reports when required by the court, that particular period, whoever is the admin, he can access and provide the report.
Sir, for example, we have just to make it a bit easy, we have in our institute that rotatory HODship. So what happens is that the person, we have various informations goes to the different to the IT department so that they put it in the website. Now the person who is a HOD, he is given the password, so he is the one who takes to it. Now the same thing is being transferred to the next person like that. Or if they feel that one particular person can handle it, provided he would be working for a few more years, it can be done like that.
Okay. Yes. Thank you.
Thank you
so much.
Thank you,
now I think it's quite a lot of time we have taken in the discussion. It was very nice discussion. So I thank you all our senior sirs to have given time here, and also Siddharth. Now I request our associate professor, Dr. Soumya Ranjan Nayak, to give a formal vote of thanks before we conclude. Dr. Soumya.
Very good evening to everybody, sirs and madams. We are extremely thankful to Dean and Principal of SCB Medical College, Cuttack, Professor Dr. Datteswar Gupta sir, for giving his valuable time from his busy schedule. His charismatic personality and encouraging words have always enlightened our path for conducting such academic fest. We are expecting to conduct many such academic meetings in future under the dynamic leadership of Professor Dr. Datteswar Hota sir. Thank you very much, sir, from the entire FMT department for your constant inspiration to us. Thank you very much, sir. Now, Dr. Siddharth Das, additional professor JIPMER, and my dear friend, it is our privilege to listen to you and your experience as head of the department JIPMER. The way you presented the topic and narrated your experience was awesome. You are the epitome of oratory skill. Thank you very much, Dr. Siddharth. Hope we'll meet very soon.
Thank you for those flowery tributes, Soumya.
Now, from the entire organizing committee, my sincere thanks to Professor C.B. Janisa for his nice deliberation. Sir, we are watching you for many years in national and conferences as former General Secretary of Indian Academy of Forcing Medicine and now Treasurer. Sir, your organizing capability is second to none. You will always remain as an inspiration to all of us. And we congratulate you for your new assignment as medical legal consultant. Sir, you are a loving person and we need your blessings. Thank you very much, sir. Janice, sir, thank you very much. Now, my heartfelt thanks to all the esteemed and knowledgeable participants for their participation and making this academic fest a successful one. We expect the same enthusiasm and energy from you in future. It is our privilege and honor to interact with others, sir, Professor Bharpur sir, Professor Ilyas Sheikh sir, and so many senior faculties in this forum. Thank you very much, sirs. Thank you very much. And at last, my sincere thanks to the support staff of Telemedicine Center, SC Medical College, Cuttack, for their cooperation in making this program successful. Thank you very much, each and everybody, once again. Thank you, sir.
Thank you so much.
Thank you, sir. Namaste, sir. Jani, sir, Bharpur, sir, Adarsh, sir, and yes, sir. Also, our Siddharth, and all the participants here who have given their time to hear from us. Thank you all. We'll take our leave, please.
Thank you.
Thank you.
Thank you, madam. Thank you. It was